My name is Jacob Weaver, and I am a senior here at Hillsdale College, and I am also president of the Hillsdale College Federalist Society. We are actually the second undergraduate chapter ever created for the Federalist Society, and we are very proud and honored to be on this campus. So that is my shameless plug of the evening. Tonight, it is my great honor and privilege to introduce one of the finest minds of our day. Judge Diarmuid F, a first-generation Irish-American, received his JD in 1963 from Harvard Law. 23 years later, in 1986, he was appointed to the United States Ninth Circuit Court of Appeals by President Reagan. Between graduation and his appointment, Judge O'Scanlan served as the Deputy Attorney General of Oregon, the Public Utility Commissioner of Oregon, and the Director of the Oregon Department of Environmental Quality. He additionally served 23 years in the U.S. Army Reserve and National Guard, including 4 years as an enlisted man. He retired from the reserves in 1978, having attained the rank of major. As a judge on the Ninth Circuit, Judge O'Scanlan has participated in over 11,000 federal cases and has written hundreds of published opinions on a broad range of subjects, including constitutional law, international law, and administrative law. He hears cases throughout the Ninth Circuit, the largest circuit court in the United States, traveling everywhere from San Francisco to Anchorage to Honolulu. He assumed senior status on December 31st, 2016. In 2004, President George W. Bush appointed Judge O'Scanlan to the Board of Trustees of the James Madison Memorial Fellowship Foundation, and Pope Benedict XVI conferred the Order of St. Gregory the Great on Judge and Miss O'Scanlan in 2007. Chief Justice Roberts appointed Judge O'Scanlan to the International Judicial Relations Committee of the U.S. Judicial Conference and subsequently appointed him chairman in 2009, and the Society of King's Inns in Dublin, Ireland, elected Judge O'Scanlan as an honorary bencher in 2016. Please join me in welcoming Judge Diarmuid O'Scanlan.
Thank you, Jacob, for such a lovely introduction. I appreciate it very, very much. I'm particularly grateful to my old friend, Dr. Larry Arnn, for his gracious invitation to speak here at Hillsdale College. I'm an eager reader of Dr. Arnn's and was impressed by the connection he drew between religious liberty and property rights in one of last year's issues of Imprimis. I commend that piece to you if you have not already read it. Now, I understand that Hillsdale continues to emphasize ancient and Western literature, along with American history and the Constitution, and in its curriculum, an emphasis I wholly appreciate. Having previously hired 3 law clerks with Hillsdale degrees, 2 of whom are co-teaching with me this week, and with Gil West's older brother on the way for the 2018-19 judicial year, I have come to learn that a Hillsdale graduate is exceptionally well-educated, well-read, and well-minded. And I would like to ask all 3 of my former law clerks who are Hillsdale graduates, please to stand, and I'll introduce them to you. From inside out is, first of all, Ryan Walsh. I don't recall your specific graduation year. Megan Lacey and James Joseph. All 3 have served as my former law clerks, and as I mentioned, Gil's brother is coming very soon, in about another year. I'm delighted to speak today on a topic that is of great importance in the American constitutional system: the increasing politicization of the judicial branch. And if you will excuse me for just a moment, I find that another set of glasses makes it easier for me to read these remarks. Allow me, if you will, to return to a time just over 30 years ago. It is 1986, and I've just been nominated by President Ronald Reagan to the United States Court of Appeals for the Ninth Circuit. Only 1 month later, I have my Senate confirmation hearing, lasting about 20 minutes, and characterized by none of the theatrics that so routinely occur today. I returned to Oregon with no fanfare, no press criticism, nor false innuendo swirling around me. A week later, I am unanimously confirmed by voice vote, and the entire process takes 6 weeks. Well, it's hard to reconcile that account of the judicial nomination process with the kabuki theater that describes judicial confirmations today. Millions of dollars are spent by interest groups either to halt a nomination or to push one through. Judicial decisions are casually labeled as politically conservative or politically progressive without any pause. Judges are routinely seen as politicians. Just take a look at the commentary and the headlines. After the Citizens United case was handed down, the Washington Post, which disapproved of the decision, described the ruling as a victory for Republicans, stating, "The far-reaching ruling marks a triumph for Senate Minority Leader Mitch McConnell, the U.S. Chamber of Commerce, and numerous other business and conservative groups." After Bush versus Gore, Jeffrey Toobin, referencing the 5 justices in the majority, wrote, "The least we can expect from these men and women is that at politically charged moments, they apply the same principles that guide them in everyday cases. This ultimately is the tragedy of Bush versus Gore." Just last month, CNN excoriated Chief Justice Roberts for not making a political statement concerning President Trump's pardon of Maricopa County, Arizona Sheriff Joe Arpaio. The headline blared, "Top judges remain silent as Trump pardons Arpaio." And then there's Linda Greenhouse, the influential legal reporter for the New York Times, who branded newly confirmed Justice Gorsuch with her version of the Scarlet Letter, Trump's life-tenured judicial avatar. And recently, during Professor Amy Barrett's confirmation hearing, some senators dusted off sordid anti-Catholic insinuations that were reminiscent of those that dogged John F. Kennedy in his 1980 presidential campaign. "The dogma lives loudly within you," explained Senator Feinstein. And Senator Durbin questioned whether Barrett considers herself an Orthodox Catholic. No mention of Professor Barrett's sterling credentials, nor the plethora of bipartisan support from lawyers and academics. The increasing politicization of the judicial branch is a cancer that strikes at the very heart of American ideal of self-governance. And I hope to outline this evening how we came to this point and how we might start the process of remission. Justice Scalia liked to say that in our constitutional scheme, structure is destiny. He was spot on. Our governing structure is premised on the principle that government must be split into co-equal, coordinate branches that check each other. This separation of powers relies on a judiciary that vigorously enforces the constitutional text against encroachments by overzealous legislators as well as executive branch officials. But the judiciary was never designed to displace these other branches. As Alexander Hamilton opined in Federalist Number 78, the general liberty of the people can never be endangered so long as the judiciary remains truly distinct from both the legislature and the executive. This concept of the judiciary is reflected in the Constitution itself. We federal judges are given lifetime appointments in order to foster independence and to encourage neutral judgment. I fear, however, that our branch is becoming politicized in a way that strays far from the original design, and no single entity is to blame. Rather, many facets of the law as an institution, from courts and judges to activist litigants to law schools themselves, have contributed to this state of affairs. Let's start with us judges. Unfortunately, we are not immune from blame when it comes to the problem of politicization of the judicial branch. Discovery of new so-called fundamental rights by judges was never contemplated in the Constitution. As Justice Clarence Thomas has noted, the 14th Amendment's Due Process Clause is not a secret repository of substantive guarantees against unfairness. And yet, not coincidentally, as the courts find, or shall we say, invent, more and more fundamental rights, political strife enveloping courts only increases. Here are some of the most memorable. In 1965, in Griswold versus Connecticut, the Supreme Court held that specific guarantees in the Bill of Rights have penumbras, and one of these penumbras is a right to privacy. In 1973, the Supreme Court gave us Roe versus Wade, which found a fundamental right to abortion. 30 years later, the court ruled in Lawrence versus Texas that a state law banning sodomy violated a constitutional right to private sexual conduct. And just 2 years ago, in Obergefell versus Hodges, a 5-justice majority of the court held that the United States Constitution includes a fundamental right to same-sex marriage. Declaring such rights by judicial fiat, rather than through robust political debate in Congress and state legislatures, has been made easier through the use by judges of imprecise interpretive methods and an unchecked temptation to play the role of legislator. Once untethered from history and tradition, constitutional text can be hijacked and deployed as an empty vessel, carrying whatever avant-garde legal theory or newly found right the judge deems worthy. In Obergefell, the court had the temerity to acknowledge that the Constitution contemplates that democracy is the appropriate process for change, but then turned around and overruled the laws of many states. And in Planned Parenthood versus Casey, which reaffirmed Roe versus Wade, we were assured that it is conventional constitutional doctrine that where reasonable people disagree, the government can adopt one position or the other. Alas, actions speak louder than words. When penumbras and the mystery of human life are used to define fundamental rights or protected liberty interests, the right of the people to govern themselves is irretrievably lost. And this happens because judges are no longer constrained to the text of the Constitution in defining such rights. It is a natural consequence of these actions that people would begin to view the judiciary, the trustee and arbiter of constitutional rights, as merely a political organ. As a judge on the Ninth Circuit, I guess I've had a front row seat. In Compassion in Dying versus State of Washington, our court, sitting en banc, invalidated laws adopted by 8 states that prohibited assisted suicide. I dissented from the court's refusal to rehear the case by a full en banc court, writing, and I'll quote this passage from the opinion, "There is absolutely no historical tradition of protecting assisted suicide. Almost all states forbid assisted suicide, and some states even permit the use of non-deadly force to thwart suicide attempts. These are the political judgments made by the democratic process. If they are no longer politically correct, let the legislatures act to change them, not life-tenured judges immune from the voters' reach." End quote. Although my concerns were vindicated when our court's decision was unanimously reversed by the Supreme Court, there remained deeper philosophical damage that reversal couldn't really mitigate. This trend continued, at times prominently, as in the 2014 case of Latta versus Otter. In Latta, a panel of our court found that the laws of Idaho and Nevada, which defined marriage as between a man and a woman, were unconstitutional. It is crucial to recall that Latta was issued prior to the Supreme Court's ruling in Obergefell. Importantly, long before Latta was decided, the Supreme Court had dismissed a same-sex marriage appeal in Baker versus Nelson, quote, "for want of a substantial federal question," unquote. Until Obergefell was decided, Baker should have guided our decision. Nonetheless, that panel reached out and grabbed for itself the authority to overrule the majority of citizens in 2 states in that case. And as I wrote at the time, and again I'll quote from the opinion, dissenting opinion, "The panel's opinion cuts short these earnest and profound debates, silencing the voices of millions of engaged and politically active citizens. Such a view eschews the very foundational premises of democratic self-governance," end quote. By ignoring Baker, our court waited needlessly into a full-throttled political debate, hobbling our claim as a neutral, independent arbiter. And so the perception persists that judges are mere extensions of political activity, reaching decisions through political and not legal choices. Might I say, with respect and regret, we judges have invited this perception. By employing legal reasoning divorced from text, history, and structure, our courts have resolved vexing social issues in place of legislatures, and consequently thrust our branch into the crosshairs of politics. As Justice Scalia said about the confirmation process, if judges are routinely providing the society's definitive answers to moral questions on which there is ample room for debate, then judges will be made politically accountable. Yet judges and courts are not solely to blame. Given the increasing propensity of courts to resolve such hot-button questions, activist litigants have begun to treat the courts like roving legislatures and not like legal tribunals. In a recent profile of the American Civil Liberties Union in Rolling Stone magazine, the author stated that Americans are looking to the judicial branch to prevent American democracy from jumping the rails. In discussing that organization and its role in our society today, the magazine exclaimed, "The American Civil Liberties Union is eager to leverage the courts and the Constitution to block the most dangerous parts of Trump's agenda." No one disputes that the judicial branch has a duty. Indeed, it is our role fairly to enforce the Constitution, including the Bill of Rights, as written. But in our system of government, recourse on matters of policy choices should be directed to Congress and the legislatures, and not to courts. These days, Congress seems only too eager to avoid having to decide crucial issues. But courts have no warrant to engage in the rough and tumble world of politics. In fact, this view of courts has become so commonplace as to be expected. In a Politico website piece discussing energy policy, the author approvingly noted, "You'll definitely find lawyers from the Sierra Club, the boots on the ground in the war on coal." As activist litigants come to be viewed as boots on the ground in policy disputes, we can expect that courts will continue to become politicized as we become the epicenter of political skirmishes. But I am afraid this view of the judiciary is ingrained and reinforced long before lawyers reach the courtroom. To my increasing dismay, law schools have undergone a sweeping shift in how they present and teach the law to students. When I attended law school at Harvard in the early 1960s, the so-called legal process school was dominant. Then we were taught that judging is limited to the reasoned elaboration of principles and policies that are ultimately traceable to more democratically legitimate decision makers. In other words, we were to operate from the common premise that judges are to apply neutral principles in an even-handed manner to all cases before them. Today, a number of professors at law schools emphasize to their students that judges are not neutral actors, but merely politicians donned with black robes. Critical legal theory, which today encompasses many subgenres such as critical race theory or feminist legal theory, is fundamentally convinced that law and politics cannot be separated. This blending of law and politics in an academic setting instills in students who are just beginning their legal careers that lawyers and judges are not operating based on text or precedent, but purely on political bias and machinations. As a new generation of lawyers takes shape, we should not expect students versed in these theories to depoliticize the judiciary. In fact, one would expect quite the opposite. Take Mark Tushnet, now a professor at Harvard Law School. Tushnet writes, "Conservative decisions on class action arbitration should be understood as part of a long-term project of defunding the left. Much of the current court's voting rights jurisprudence strengthens Republican efforts selectively to shrink the electorate." I doubt that you would hear such an academic insight promoted on this campus. The insinuation is damning. Even if Professor Tushnet acknowledges that these doctrines are not consciously designed by judges to achieve these effects, in the same piece, Tushnet, anticipating a Hillary Clinton presidency, encouraged appellate judges to flout the law in favor of progressive political goals, saying, "Right now, more than half of the judges sitting on the courts of appeals were appointed by Democratic presidents. Those judges no longer have to be worried about reversal by the Supreme Court if they take aggressively liberal positions." Richard Posner, an influential and oft-cited former judge on the Seventh Circuit and a senior lecturer at the University of Chicago Law School, once compared constitutional decisions by the Supreme Court to choosing between a margarita or a cosmopolitan. "It is rarely possible to say with a straight face of a Supreme Court constitutional decision," he wrote, "that it was decided correctly or incorrectly." Indeed, Judge Posner has suggested that, in his words, judges have to be political animals. Such cavalier analysis affords students, and others for that matter, the opportunity to blame decisions they do not like on politics. It devolves legal analysis into cable news punditry and pressures the next generation of attorneys and judges to approach legal issues with the eye of a politician and not of a lawyer. Some of you may react to the increasing politicization of the judiciary by asking, "So what? Why should I care?" To share the answer to that question is to recall the singular building block upon which the judiciary rests: legitimacy. As Justice Scalia reminded us in his Obergefell dissent, and I'll quote, "With each decision of ours that takes from the people a question properly left to them, with each decision that is unabashedly based not on law, but on the reasoned judgment of a bare majority of this court, we move one step closer to being reminded of their impotence." Unquote. Justice Scalia was right to sound the alarm. The American public's faith in institutions is at an all-time low. Only 12% of Americans have a great deal or quite a lot of confidence in Congress. Just 21% of Americans have this level of confidence in big business, and only 27% in newspapers. At the current moment, 40% of Americans have confidence in the Supreme Court. Nonetheless, it would be folly to believe that the courts are any less immune from public backlash than Congress or newspapers or industry. If the public were to lose faith in the courts, believing that courts were not neutral arbiters, but political actors, the judiciary would be at risk of losing our legitimacy. As Hamilton reminds us in Federalist 78, the executive branch wields the sword and Congress holds the purse, but reasoned judgment, and not the sword or the purse, is what inclines the other branches and the public to respect our decisions. Otherwise, we may not be too far off from a repeat of President Andrew Jackson's famed retort to Chief Justice Marshall's decision in Worcester versus Georgia: "John Marshall has made his decision, now let him enforce it." After all that, do I despair? No. I remain ever hopeful that the creeping politicization of the judiciary can be decelerated, if not reversed. I have two thoughts on how we may move forward. One for me and my colleagues, and one for all of us here tonight. First, judges must be vigilant in resisting any temptation to let our personal political beliefs, conservative, liberal, or otherwise, guide decision-making. Our constitutional role to decide cases and controversies, it's nothing more and nothing less. The further we move away from our anchors in interpreting the Constitution, text, precedent, structure, and history, the more we resemble a legislature and not a court. Humility is paramount in staying within our constitutional sphere. We federal judges are not elected by the people, and we are cloaked with life tenure. Once again, I must turn to the ever-prescient Justice Scalia. Hubris is sometimes defined as o'erweening pride, and pride, we know, goeth before a fall. One need only look down at our courtroom attire to be reminded of our role in the American system of government. Judges wear black robes because when we ascend to the bench, we represent the law and not our personal selves. I am heartened by the appointment of Justice Gorsuch, who stated in his confirmation hearing, "These days we sometimes hear judges cynically described as politicians in robes, seeking to enforce their own politics rather than striving to apply the law impartially. But I don't think that's what a life in the law is about." All right, second, good citizenship. And here's where you come in. We as a society bear responsibility for our system of government. As Benjamin Franklin departed the Constitutional Convention, he was asked by an onlooker what type of government the delegates had agreed on. "A republic, if you can keep it," he replied. Good, engaged citizenship starts with education. Alexis de Tocqueville, the great observer of American society and culture, noted, "In the nations by which the sovereignty of the people is recognized, every individual possesses an equal share of power. Every individual is supposed to be as well informed, as virtuous and as strong as any of his fellow citizens." Essential to our republic is appreciating that courts are not the fora for public policy disputes. Legislatures are. We should not decry the silence of courts on political questions. We should celebrate it. Perhaps you can begin by demanding that Congress do its duty by taking up the pressing issues of our day instead of defaulting to the judiciary, as it so often does. Try resisting the urge to seek redress through activist interest group-driven litigation. Instead, seek to engage your opponents in order to find resolution, and definitely challenge those who insist on confusing the role of a judge with that of a legislator. This type of good citizenship is not just to be instilled in law schools, but in all schools, including colleges. At Hillsdale, you have such an opportunity, and I see from my experience how well you are doing. Virtus tentamine gaudet. Strength rejoices in the challenge. As stated so eloquently by Alexander Hamilton years ago, judges have neither force nor will, but merely judgment. If we stick to judgment, not political policy choices, and engender a society that understands the judiciary's role, our country will be all the better for it. Finally, I hope that 30 years from now, judicial confirmation hearings, perhaps with a Hillsdale graduate at the nominees table, will more closely resemble my confirmation experience 30 years ago than what we see occurring today. Thank you very much. I will be very happy to take questions if there are any. Yes, right in front.
My name is Spencer. I'm a freshman from Nebraska.
Okay.
My question for you, you mentioned overruling the majorities of states in the Ninth Circuit. What is your position on the 14th Amendment and when the judicial system can overturn majority decisions?
Oh my, you should be taking the class that my former law clerks and I are teaching this week. You can take it next time, Your Honor. Okay, let's do that. I find that to be a very general question. There will be occasions where there is a state statute which violates the command in the 14th amendment, which speaks directly to states, that is in direct conflict with the provisions of the United States Constitution. We do that on occasion, and hopefully we do it with a rationale and an explanation which is complete and which relates to the direct provisions of the Constitution and very often precedents. We spent the entire day today discussing the extent to which we have to follow precedents. But in general, that's the role that we have to apply. Other questions? Yes.
So, how do judges get together and talk about these things?
Well, it's amazing. I happen to be on a very far-flung court. We occupy 1 million square miles of territory. We include Alaska, Hawaii, 2 territories in the Central Pacific, Guam and the Northern Mariana Islands, to say nothing of California and my own state of Oregon and 4 other states. We do get together for court meetings quarterly. The meeting usually starts with lunch being served at noon. The meeting starts at 12:30. We're usually done by about 2:30, and everybody rushes to the airport to get on their flights to go home to their different states. I don't think we do enough getting together to really talk through some of these things. Now, we do, obviously, when we hear a case, we'll retire to the conference room, the robing room, where we will sit down and decide that case. More often than not, it seems to me at that stage, we don't invest the kind of time that is really necessary to accommodate, I think, what you're getting at, and which I would like to see more of. But keep in mind that before we hear the case, there is a lot of work that's already been done. There's a bench memorandum has been prepared, which typically is fairly thorough. And if any one of us feels that the bench memorandum does not go into sufficient depth, why our own law clerks will supplement that so that at least each of us, to the extent any one of us feels the need, we can have that additional help. But I think it would be more healthy. And even when we have our annual retreat, it's all on court administration. There's very, very little discussion on judicial philosophy or the kinds of things that I was talking about today. Yes, right here.
Thank you so much for coming. I'm Connor Daniels, a freshman here. My question is related to the Ninth Circuit itself. There have been several commentators that have suggested maybe dividing it due to its size and the great number of cases it has. Based on your experience, how do you think that would work in practice?
Well, I'm one of the supporters of legislation which would restructure the Ninth Circuit, and I came to that conclusion about 5 years after I came on the court, which is 25 years ago. There's a little bit of history. In 1974, Congress created what's called the Haruska Commission. That was chaired by Senator Haruska of Nebraska. And it concluded that 2 circuits should be restructured. The 5th, which is, at that time, was Texas, Louisiana, Mississippi, Alabama, Georgia, and Florida, that the 5th should be restructured and that the 9th should be restructured. They suggested that the 5th be restructured so that a new 11th Circuit would be created by Georgia, Alabama, and Florida. A few years later, the 5th Circuit went ahead and did that. Our circuit judges at that time, I was not on the court till '86, decided to resist. and to maintain the court in its present alignment. A number of bills have been entered for consideration ever since then. In one case, one house of Congress actually passed a split bill. But the issue kept percolating, so that a few years ago, in a commission chaired by Justice White, the recommendation was that the Ninth Circuit be split basically into 3 semi-autonomous divisions that would function as sort of semi-autonomous circuits. Nothing happened on that either. This year, I have to tell you that there's a lot of activity going on. There are senators from Idaho, from Alaska, and from Arizona, all of whom have pending bills, as well as congressmen from various states. And I think there are about 4 different alignments that are suggested. The one I personally prefer is the one that would have a new Ninth Circuit, which would only be 3 states. It would be California, Hawaii, and Oregon. The remaining 6 states would be a new 12th Circuit. I testified actually before the Senate Judiciary Subcommittee about 3 weeks ago at a special hearing in Phoenix, Arizona, in support of that proposal. And all I can say is that it seems to have some movement, some momentum behind it. But unfortunately, my arguments for splitting the circuit are administrative. The circuit is twice as large as the next largest circuit and 4 times as large as the smallest circuit. We have 29 judges on the court, so that we can never sit in bank. Now, sitting in bank means you sit with the full court. We only sit with 11 judges, whereas every other circuit, including the second largest, which is the Fifth Circuit, which has 17 judges, they do sit with all 17. We have never sat with the full number of judges in our court. And there are other administrative reasons to support it. But in the end, regrettably, the administrative analysis will probably not prevail. What will prevail is perceptions. On the right, the perception is our court is much too liberal. On the left, the perception is we don't want to give up the liberal reputation that we have. And that battle will continue to engage. So keep an eye out for it. It is active. This is not a dormant issue as it had been for the last 4 to 6 years. This time round, there's some action. Okay, next question.
Thank you, Your Honor. My name is Bryce Asberg, and my question is about the blue slip process.
Oh, yes.
There's been a lot of talk lately, and I'm sure it hits home close to you with the nomination of Ryan Bounds and Oregon senators withholding the blue slip process. So my question is, do you think there's abuse there, and what can we do, how do we respond to that with the goal of stemming the tide of politicization in the judicial branch?
You students are very, very well informed. I'm very impressed. When I took senior status on January 1st of this year, that created a vacancy. Under our system, federal judges are appointed for life, but after they have served 15 years and have reached the age of 65, they can elect senior status, which means they can take a lesser caseload, and they don't have to sit on certain types of cases. I reached that stage quite a few years ago, but I kept my active status until the end of last year. President Trump has nominated a former law clerk of mine, Ryan Bounds, to fill my position. We have two Democratic senators, Senators Wyden and Merkley, and there's been a dust-up, which is outside of my realm, but a dust-up between the White House and the two senators. The two senators have said, wait a minute, we want to have a selection committee, and we'll, in effect, tell you, Mr. President, who we'd like you to appoint. The process of setting up the committee it took such a long time, according to the White House, that they went ahead and made the nomination anyway. And so now the two senators have announced that they will not return the blue slips. Now, the blue slips, it's amazing. It's just a piece of blue paper that the chairman of the Judiciary Committee sends to the senators from the nominee's home state. The idea is that the senator has an opportunity to tell the chairman that this nominee is either personally objectionable, in which case he won't return the blue slip, or he has no objection to the nominees continuing through the process. Chairman Grassley will, up till now at least, will only set hearings for nominees for whom their home senators have returned these blue non-objection slips. That's what that process is all about. We are perhaps getting into a fairly remarkable parallel to some of the situations I described in my speech. But in terms of my specific vacancy, neither senator has indicated any objection to Ryan Bounds' qualifications. He is a graduate of, I think he was a graduate with honors from Stanford, and then was on the Yale Law Journal at Yale Law School. He was in the Justice Department as a Deputy Assistant Attorney General under President Bush. He had been in a private law firm, but more importantly than anything else, he was a former law clerk of mine. So, but the senators have no objection to any of that. The objection is that they think the White House should have waited longer until they had set up a commission which would then entertain applications from others. Indeed, in the specific case of this vacancy, the senators did say that we would like you to appoint a sitting district judge who, until that happened, had expressed no interest in being considered. The White House was under no obligation to entertain that suggestion, but it went ahead and did anyway. It invited Judge Hernandez to come back to the White House where he was interviewed. He was also interviewed at the Department of Justice. The White House, which had interviewed others as well, had came to the conclusion that they would still like to stay with Ryan Bounds, and so notified the senators, and hearing nothing further, went ahead and nominated Bounds. Okay? Other questions? Let's get some questions from elsewhere. Pardon? Dr. Arnn has a question. Oh, my heavens. Uh-oh.
So that was inspiring, Grace, as to be expected. I would like to place it in context. So, big context. So I think the greatest things that judges have ever done, and the reason some of them are heroes, and the reason the judges as an institution deserve the power that they have and the lifetime tenure that they have, is that they have stood up to executives and legislatures which have armies behind them. And if you want to see if a country is a good country, just look and see if the son of the prime minister or whatever the tyrant is called will have no better chance in front of a judge than you have. And there are lots of countries today where they don't, and in some of those countries, where the powerful do have a better chance, and in some of those countries, judges do brave things. So your talk was about judges not being haughty and making laws. But we live in a time when we have more law than we've ever had. And those laws are made by a very different process than the Constitution describes they should be made. I looked it up this week for another reason, but I happen to know that last year the Congress of the United States passed 1/2 of 385 laws. So the 2-year Congress passed 385 laws. But last year, in a single year alone, the last year of Obama, 87,000 pages of law were added to the Federal Register. And that's the most in history, and that came from an administrative system that, in my little opinion, is unconstitutional. But never mind that, it certainly is not named in the Constitution. So now I wonder if in that circumstance, and given the reasons judges have the respect they have, where it was born, I wonder if you think judges are in fact not way too shy about contesting laws that circumscribe the rights of individuals.
Well, you have to keep in mind that we can only rule on cases that are brought before us. And not every case would provide that kind of opportunity. But when the proper case is brought, in other words, there's proper standing, there is injury asserted, and there is an invocation, let's say, of a constitutional right, then we will decide it. I don't know. I think some of us are pretty stout in taking on cases and deciding them. Well, on Chevron, okay, that's a rather specific question. I thought it was broader. There is what's called a so-called Chevron doctrine, in which the Supreme Court, in a case involving Chevron, that's why it's called the Chevron doctrine, allowed the administrative agency whose regulation was under consideration to, in effect, interpret the statute involved. The challenge was that what the agency did not comport with the language of the statute. But the doctrine that came down was that so long as the statute is ambiguous, in other words, so long as you could say that this federally passed congressional act has language which could be subject to multiple interpretations, then the agency charged with the implementation of that statute has standing and indeed must be given deference because of its experience with the statute, its role in administering that particular area of the law. Some of us have serious question about whether that doctrine is valid as a constitutional matter. Ironically, Justice Scalia had no trouble with that doctrine for quite a long time. And it wasn't until his rather latter days that he began to suggest that it really needs to be re-examined. Now, I think Justice Gorsuch has already gone on record as expressing doubts about the Chevron doctrine. But from where I sit as a judge on an inferior court. Now, I hope we're not inferior because of the people that are on the court, but we are one rank below the Supreme Court. My role is limited to following Supreme Court precedent. I can't on my own, although those of you in class this week will give some thought to, well, maybe I have just as much right to interpret the Constitution as a Supreme Court justice does.
Now you see what they like.
Yeah. It's quite likely, I would have to say, that sometime in the next couple of years, the Supreme Court will have a case which will reconsider the Chevron doctrine. And if I have the opportunity, of course, I'll have to follow the Chevron case, but I do have some arrows in my quiver. The most important one, I guess, is the ability to write a special concurrence. In other words, I can concur in the judgment which follows Chevron, but say that Chevron has these problems and cite to cases which have expressed concerns, as well as some of the writers in the field who have expressed concerns. So that option is available to me.
We have time for one more question.
Right over here.
Okay. All right. So in your speech, you were talking about how you didn't appreciate that we derive rights that aren't explicitly guaranteed in the
Could
Bill
you
of
speak a
Rights.
little louder? I'm sorry, I'm having
Okay.
trouble hearing you.
So you were just talking about deriving new rights and how you think that that's not good jurisprudence. And so my question was, are you of the train of thought that the right of privacy was illegitimately derived, or do you just object to how Griswold applied what Brandeis said in Olmsted about speech to something else? So what did you not appreciate about deriving that right of privacy?
Well,
the whole
the
thing?
word
or just-
privacy isn't in the Constitution whatsoever. And regardless of how you might feel on the merits of whether that particular Connecticut statute was, whether you liked it or not, the point is that there is no such protected right as such in the Constitution. Now, this is one of those areas where it's going to be very, very, very hard to overcome that precedent that has now come down, because it's gotten so widely noted. There could very well be a case coming down which might cabin the right in some way, but to overcome Griswold, I just don't see it in my lifetime. But of course, I'm 80 years old, so it'll probably take longer than that.
So it's the penumbra
thank
that
you.
you don't appreciate. So it's just the penumbra idea that is not good, good interpretation.
Okay, I think that was Justice.
Because that's kind of how
I'm sorry.
that's kind of how the privacy was derived. It was a penumbra of the fourth.
Yeah.
So it's
The writing justice, and I'll think of his name in a moment, but he just developed that. I mean, that's poetry.
Mm-hmm.
That's not law. Really. It's kind of existential interpretation without any of the tools that are recognized in terms of constitutional interpretation.
okay.
But you'd be amazed how widely quoted the penumbras which emanate from, the penumbras from emanations from certain rights. That language has been quoted in many, many cases. without any real firm foundation, and I regret that, but I'm
So
afraid
then
that's where we are.
That's something we live with then, right?
Yes.
Yeah,
Well,
because we respect precedent.
As I told you, in the right case, and I've done this quite a number of times, and I'm happy to say that on a number of occasions, the Supreme Court, if I've written a dissent from a failure to rehear in bank, or if I've written a separate concurrence pointing out the problem, the Supreme Court notices these things, and at least in a number of cases has used that as a vehicle to change or overrule a case which just overstepped its bounds.
Yeah, thank you.
Thank you.
Thank you.
Okay? All right.